This was a fascinating case because this case presented really several of the ultimate challenges to taking a case to a jury. It was a very minor impact. You couldn't even see the damage really to the plaintiff's vehicle in the photographs, and she had very little treatment during the year following the crash. She then had about a 3-year period where she had basically no treatment. We argued to the jury that she was surviving on home exercise and Vicodin. And then she finally met Serena Hu, the head of spine surgery at University of California, San Francisco, who did a disc replacement surgery on her about 4.5 years after the crash. The challenge in this case really was figuring out how to show the jury the difference between impossible and unlikely. And that really was what the whole focus of this trial was. It's unlikely that you would suffer an intervertebral disc injury in a very minor 3 to 5 mile per hour impact, but not impossible. The solution was to bring in a forensic epidemiologist who was an expert in injuries from car crashes. And in this case, Dr. Freeman relied on the 2 huge look-back studies done in Copenhagen and Japan, where they looked at over 40,000 actual accidents to determine the forces of the impact and the injuries suffered by the occupants. What we found by reviewing these large look-back studies was the really surprisingly high frequency of injury in even low-speed crashes. Dr. Freeman presented to the jury how in even a 5 mile per hour crash, there's a 1 out of 3 chance that the occupants of the vehicles will have some type of injury. In a 10 mile per hour crash, we found that frequency of injury actually went up to 2 out of 3. The most important fact that we were able to show the jury in our case was that statistically there was actually a 1 out of 40 chance of having a disc injury in even a 5 mile per hour crash. So while my client again was unlucky, it was not impossible that she suffered her claimed injury. The plaintiff, Susan Ice Dunnigan, was a very pleasant woman in her early 40s. She had a couple of young children. She'd been through the ringer a bit. This case had been going on for many years. She had had years of back pain followed by several surgeries, and she really, used up the empathy that any of her friends or family may have had for her at one point, and we had to come up with a way to visually show the jury how to compress the 6 years of medical treatment and make it relate to this crash back in August of 2006. The charts that we ended up preparing showed that while my client wasn't actively receiving treatment during the entire 6 years after the crash, when you compared it to the level of treatment that she had had before the crash, her pre-accident and post-accident medical profile were vastly different. State Farm had never offered a dime on this case for almost 6 years, and 5 days before trial I was personally served with a late 998 offer for $22,000. The juror's verdict in this case was a little over $1.4 million, and with prejudgment interest and costs, State Farm ended up paying substantially more than that. This case was a perfect example of the really great part of representing individuals like I do and like many of us do in serious injury and death cases. I was able not only to validate my client's injury that had really changed her life in a significant way, but also finally get her some compensation and some relief for the years of struggling that she had as a result of this crash.
Mr. Duncan worked for a bus company, a private bus company that got contracts to transport people under various different circumstances. Sometimes it would be a one-day trip, pick up people at one spot, take them to another.
I think when I look back 20 years from now, he's still going to be one of those clients that's just going to have a special place for you. And we got really close. I got close with his family as well. He grew up in Oakland and resided there with both his mother and his grandmother that was 102, I believe, on last check.
As he was driving the bus, this was early morning hours at this point, late at night, dark, a semi truck that was exiting the freeway on Highway 80 was coming down at basically a right angle to the direction Mr. Duncan was traveling, and the big rig driver was traveling too fast and couldn't make the left turn, and in turn ended up hitting Mr. Duncan's bus right about the area where Mr. Duncan was driving.
I'd say up until maybe a few weeks before trial, the defendants just never took this case seriously. There was a contention throughout that there wasn't much insurance there, that a number of the defendants weren't liable at all, and that even if they were liable, the client really wasn't that badly injured, and he was lying about both his injuries and the extent of them.
Velasquez and Sons was driving this particular load because they had been contracted by a company called Sun Valley Express, which had a contract to haul these particular grapes. Sun Valley was a trucking company that had a contract with a company called G3 Enterprises, Inc. I went to trial thinking I had to prove that G3 was a motor carrier for hire. I figured if I could just show they were a public motor carrier, and the way I was going to do that was by pulling out some motor carrier licenses and say, see, motor carrier, authorized for hire, what happened here, they got hired, so they must be a motor carrier for hire. I mean, it turns out, once we got into trial, suddenly Paul Hastings, the big law firm, got involved and showed up and started arguing to the court that in order for us, the plaintiffs, to show that G3 was a motor carrier for hire, we had to show all these other things. In particular, we had to show that the goods that were on this particular load were destined for out of state. Further, not just that the load was destined for out of state, but it was destined for out of state in the condition in which it was in when the accident happened, which is grapes as grapes, not grapes as wine. So at the end of the day, the jury came back and determined that Mr. Duncan's total damages were well over $4 million. They gave us every penny that we asked for in economic damages. They gave him $2 million in general damages. It was that following Monday when the verdict came in from Duncan, and Anush Lancaster called me with the verdict. I continued to do all the depots the rest of that week, and then that following Monday, 10 days later, we started the will trial in Monterey, California. The will case was about a guy named Matt Will. Matt was a young CAL FIRE heavy fire equipment operator who basically fights fires for the state of California in wildlands. On the day of the accident, Matt was driving a bulldozer, a Caterpillar bulldozer, and he was using a newer version of the bulldozer on a slope that was 100%. The dirt underneath the bulldozer slipped out, and his bulldozer ended up rolling down the hill.
The biggest issue was that this was a bulldozer with a ROPS, which is a rollover protective system, and that Caterpillar knew and was marketing these bulldozers to CAL FIRE for use on fires with the potential that they would roll over. And here our client had rolled over, and the dozer was just fine, and our client was dead.
He was likely being thrown about inside the cage of the bulldozer, the rollover protective structure. The evidence that I think really won the case for us at the end of the day was two patents that we found, one from 1971 and one from 1974. And these were patents that described in detail the dangers that bulldozer operators face in the event of a rollover. And in fact, it shows these great pictures of an operator who's moving from side to side in a simulated rollover as part of the patent application itself. In one, it's a 4-point restraint seatbelt with a seat that is able to absorb some of the shock, and also had side bolsters to prevent the person from moving too far laterally one way or another, which of course is what happened in Matt Will's case. So in one of the other patents, there was this demonstration of how airbags could be used to protect an operator that would be on the side. Caterpillar argued that all of these things were not feasible, that they couldn't be done, they would make an operator less safe. Amazing things about these patents is that both of them were patents that were held by Caterpillar. The verdict after trial ended up being over $5 million for Dee Dee and the kids.
once Diana Will lost her husband, she really saw her job as being picking up the pieces and moving forward and just protecting her kids and doing the best she could. So throughout litigation, she really didn't have much involvement with the case. She didn't want to know details of the accident. And at the end of trial, we encouraged Diana to attend the closing statements, which she was pretty resistant to do. And I remember going to lunch after the closing statements, and she said, "It feels like two different cases were going on." After the verdict came back and she'd had a few weeks to process, she called me and she really thanked us for encouraging her to be part of the process. I think it really offered closure for both she and the kids, to realize that her husband was human, that there were a number of factors that contributed to this accident, but at the end of the day there were culpable defendants that should have done something differently.
I first heard from Calla Felicity in a phone message she left on my answering machine, and it was this hushed voice. I could barely understand her, but I heard something about her having swallowed a 2-inch chicken bone and being in the hospital.
Well, Calla Felicity and LaRose, her partner, are wonderful women who both have legal background. Calla was a paralegal for years, and LaRose was a lawyer.
The way the incident happened was that Calla and her 82-year-old mother, Ruth, were at a Round Table Pizza down in Daly City, and Calla ordered a barbecue chicken pizza, which she started to eat, and then she noticed something go down her throat that felt a little odd. She thought it was a piece of crust, and she went through a lot of effort to cough it out, couldn't really do it, but thought it was a piece of crust, so she just went home and went about her business.
Over the next couple of days, Calla felt that it wasn't resolving. She thought, oh, well, it'll just go away. And then she started to have more pain and more pain, and then she had a lot of pain, and that's when LaRose said to her, look, Calla, we're taking you to the hospital. When she swallowed the chicken bone, it went and lodged in her esophagus, in her throat, and it ruptured her esophagus, causing a small hole, which later became larger and allowed fluid from her throat to go into her chest cavity.
In terms of Round Table, that case was really about as close as a slam dunk as you can find, because we had admissions from their managerial employees and their line level employees that they did not inspect for bones. Now, in terms of Foster Farms, a challenge was that this case involves, one of the largest chicken producers in California and really the country, and I'm no chicken expert, so I had to get smart on chicken, and this involved hiring experts and doing a lot of focused discovery and touring their plant.
Foster Farms had quality control, which allowed for, during the inspection of sample batches of their chicken strips, they would identify whether or not there were bones in any of those in that batch. It allowed for 1 bone per batch. They were passing batches that had more than 1 bone per batch.
In terms of discovery of other incidents, which I think has to be standard practice for anybody doing a food product case, we did not have to bring a motion, but we did have to go through the meet and confer process to force this out of them. And they produced a spreadsheet for us, actually a couple of different spreadsheets, but this is the one that got into evidence, with 206 other bone incidents in the same or very similar chicken product. And what I noticed when I looked at these 206 incidents was that at least 30 of them involved children. And so we created some very simple graphics where we called out each of the other incidents that involved a child. And this was clearly the use of the reptile theory and making the jury realize that this case wasn't just about Calla Felicity, it was about food safety in our society.
Her testimony at trial was given in her voice that was obviously strained and not her normal voice. And we were able to play a recording from her telephone recording, or answering machine, that was her normal voice. And the comparison of the two was startling, frankly.
In terms of the settlement negotiations, we had a mediation early on that, although we had high hopes for it, they announced their plan to defend their product all the way to the end. They only offered $50,000. The verdict ultimately was $2.5 million, which was to the penny what we asked for in our closing argument.
I think what I'm most proud of is the fact that Chuck and I were able to work together as a team so effectively. We really were able to be thorough. We were persistent. We were able to come up with ideas together about how the case should be tried that I think individually we might not have been able to do.
I am a latecomer to the world of the plaintiff's bar. The first 10 years of my career, approximately, was spent doing defense work for law firms. And the last 15 years, since starting Paoli and Gearhart, I've been doing all plaintiff's work. And I often say if there was one thing I would do differently in my career, it's that I would have started being a plaintiff's lawyer from the get-go. When I was a defense lawyer, I never had anybody, any corporation or insurance company, say thank you for a job well done. As a plaintiff's lawyer, I get cards and letters several times a year from my clients thanking me, and that says it all.
Candace came to me in 2009, and she said, I want a lawyer who will take this case to trial because we need to bring attention to the Jehovah's Witness policy of keeping sex abusers secret, and we need to make them change it. And I agreed. The plaintiff in this case, Candace Conti, grew up in a life of chaos. Her mother was a substance abuser with major psychiatric disabilities, unable to care for herself or her child. Her father, so dedicated to the Jehovah's Witnesses that he abandoned his family. And Candace left as a vulnerable girl at age 9 and 10. Candace grew up in a Jehovah's Witness family, and she was dedicated to being, as she told the jury, the best Jehovah's Witness she could be. And that was her life's passion at 8 and 9 and 10 in response to this dysfunctional family that she was raised in. Jonathan Kendrick, who is the perpetrator of the abuse of Candace, was a ministerial servant, that's a lower level position, in the congregation in North Fremont that Candace and her family belonged to. He was reported to the congregation elders for having sexually abused his stepdaughter in 1993 and was criminally convicted of that allegation as well. Candace continued to go to what is called field service, even though her parents were often unable to join her. And she would go as a 9 and 10-year-old, door to door, as so many of us have been awakened on Saturday mornings, spreading the policies and the preachings of Jehovah's Witnesses and raising money for Watchtower, New York. It was during field service that Jonathan Kendrick, who was assigned to go out into groups with Candace, even though the elders knew he was a child sex abuser and was likely to abuse again. And he would take Candace during the middle of the field service to his house and commit terrible acts of abuse of this little girl. In 2009, Candace learned by checking the Department of Justice website that her perpetrator, Jonathan Kendrick, had been convicted of abusing another 8-year-old girl in a different congregation in Oakley. And she went to the elders in Los Angeles, where she was living at the time, and asked them to change the policy of keeping known sexual abusers secret. And she said to them, "What's to prevent them from hiding who they are?" And the elders refused to change the policies, refused to even report to Watchtower, New York, the corporate headquarters, the experience that Candace had. Exhibit 1 in the trial was a written policy of Watchtower, New York, issued on July 1st, 1989, meant to be kept confidential, but we were able to obtain it through the power of the court, which instructed all elders in the entire United States to keep reports of child sex abuse secret. In closing argument in the compensatory damage phase, I asked the jury for $7 million for Candace's abuse, her years of darkness when she was in isolation and couldn't tell anyone, her years of anxiety and drug abuse and post-traumatic stress syndrome, and the rest of her life. And the jury awarded $7 million. In the punitive damage phase, I asked the jury for treble damages, $21 million. And they awarded $21,000,001, because the jurors told us later this verdict needed an exclamation point.
It was a very hard road, but the message also is that other people can do this. You can do this. If I did this and I stuck through it, it was really hard, and there was a night there that I really questioned wanting to continue, but it's worth it, and you can do it. It doesn't matter anything else. You can really stand up and get through it.
The thing I am most proud of in terms of my work in this case is after the verdict, which got worldwide attention. I got more than 1,000 calls from every continent except Antarctica from victims of Jehovah's Witness sexual abuse. And afterwards, they changed their policy. They didn't change it as much as they should, and it's going to take a lot more lessons, but they did change it enough, and they moved it in the right direction. And we brought attention to a dark secret in that church. This is the first verdict ever against Jehovah's Witnesses in the United States. And we proved the importance of protecting children, because this is the largest verdict ever given in the country for a single victim of religious child sex abuse.